Well, this is wonderful. Welcome everyone to Curtin Law School and to this very special session. It's taken us a few years to get the Honourable Michael Kirby AC CMG here with us, and we're very honoured that you've been able to make the trip across the Nullarbor. For those of you who don't know me, my name is Robert Cunningham, and I'm of course the Dean and Head of Curtin Law School, and also a practicing barrister here within Murray Chambers. Nagala Karichnunga Mort Karak Nijabuja. Nagani Karichnunga Kabalik Burn Kuriye. It's acknowledged that this event is taking place on Wajak Nunga Buja, and respect is paid to the Wajak Nunga leaders, past, present, and emerging. And I draw our attention to the transition of the Noongar seasons from Makaru to Jilba. And it's of course, many of you will know, given your exposure to this building, the history of 57 Murray Street, particularly the role that A.O. Neville played in administering the stolen generations policy of this state between around World War I and World War II. For those of you who haven't seen the Rabbit Proof Fence movie, I would invite you to have a close look at that film and to look at the role of A.O. Neville as one of the protagonists in that narrative, which is of course an entirely true narrative. The purpose of today is to make it very free-flowing and interactive, and I know from past experience that the Honourable Michael Kirby thrives in environments around law students. I've seen that in action on many occasions, and almost in every speech I've ever heard you give, you've always mentioned law students, which is something that I've found to be very special, because I know that you hold legal education as something very dear to your heart. For most of you, the Honourable Michael Kirby AC CMG needs no introduction, but let me just remind you that he sat on the highest court of this country between 1996 and 2009, and of course before that, between 1984 and 1986, presided over the highest appellate court in New South Wales. We're also fortunate today to have Stephen Keim SC with us, who of course is online. He's appeared in a number of cases before the High Court, but perhaps most importantly for today, it is the case of Love and Tom's. In fact, Love and Tom's is in a sense two cases, but perhaps we'll get to that as we move through today. And more recently, I was also involved with a case in the federal court by the name of Helmbright, where Stephen was also acting. So that might be a case that we also discuss today as we traverse the Mabo decision through to Love and Tom's, and perhaps think about where to from here. And of course, we have the man of the moment here as well, Greg McIntyre SC, who part of this day today is to open the Michael Kirby Chambers, which was officially done a few hours ago. And we also have esteemed members of the Michael Kirby Chambers here as well, such as Brian Nagawella at the back there, who has been very instrumental in organising today's proceedings. So the way in which I envisage this will work is that I'll hand the baton to Greg in a moment to talk a little bit about Mabo number 2 and to offer up some reflections. I will then invite Stephen to talk a little bit about Love and Tom's, and then we will seek to reverse engineer the gap, if you like, between 1992 and 2020 to think about in a sense, where we might be going into the future. But I invite you to be engaged, to ask questions. There's no such thing as a stupid question in this building, ever. So feel free to ask any question that comes to mind. And it may be, if we've got time at the end, that we move away from the substantive content, and there might be one or two questions about what it's like to be a judge on the High Court, or that type of line of questioning. So without further ado, I think I'll hand it over to Greg to have a few reflections about Mabo number 2, and then we'll, as I say, take it on to Stephen to talk about Love and Toms. Thank you.
Thank you, Robert. Some of you may know that today, the 9th of August, happens coincidentally to be the United Nations Day of the World's Indigenous Peoples. It was established by the United Nations to raise awareness and protect the rights of the world's Indigenous peoples, population, and to recognise the achievements and contributions that Indigenous people make to improve world issues. And there's a particular focus this year on the role of women in preserving Indigenous traditions. You may also know that UNESCO declared 2019 the Year of Indigenous Languages, and then went on to declare this decade as the Decade of Indigenous Languages. And so, knowing that, I sat down with Professor Len Collard from the University of Western Australia and learned to make an acknowledgement of country in the Noongar language as follows. Kaya, nyon kadich nyonin wajak Noongar buja, nyon burunin kwak kadich ganya, niche balbidja albuja, kura yaya burawan Kaya. Now, what I'm going to principally speak to you about is the Mabo decision and provide a link, which it has, of course, to Love and the Commonwealth. At page 10 of the reported decision of Justice Brennan in Mabo number 2, he said this: membership of the Indigenous people depends on biological descent from the Indigenous people and on mutual recognition of the elders or other persons enjoying traditional authority among those people. Now, he also spoke of an identifiable community, and it's really from those sorts of words that the High Court has drawn the conclusions that they've reached in Love and Toms. We were discussing as we were coming across in the motor vehicle the difference between a ratio decidendi and an obiter dictum. Clearly, what Justice Brennan had to say about that was significant, but it might be said that it wasn't crucial to the ultimate decision in Mabo and Queensland number 2. I was the solicitor who issued the writ in the proceedings in 1982, and then acted in a team with the 3 barristers whom I briefed from the Melbourne Bar, Victorian Bar, and we were finding our way. We were told by Eddie Mabo that he and the Miriam people held individual plots of land which they inherited from their ancestors, and so our pleadings commenced by pleading the individual claims of the 5 plaintiffs whom we ultimately selected from a process of proofing and meeting with the community. Fortunately, we also pleaded in the alternative a community-based connection, but we didn't know until the High Court brought down its decision what it would really say about all of that. At one level, even now in Native Title Act cases in the Federal Court, there is still a feeling of the way as to what constitutes the necessary group in relation to native title. And there are many answers to that question. So we started with an individual saying, well, I hold a traditional title. The Passy family, interestingly, instructed us that they held title as a family group, and that the senior member of their family group controlled how land was allocated between them. The High Court eventually found, as you know, that the Miriam people held native title as against the world, Now, there was no real definition of who the Miriam people were in any of the pleadings, in any sense which a legal practitioner would normally want to plead that kind of thing, knowing that that was going to be the question answered. We had an interesting moment in the hearing of the case at the conclusion of Senior Counsel Ron Caston's submissions to the High Court, when Sir Gerard Brennan leant over to Sir Anthony Mason and they said something to one another, and Sir Anthony Mason then said to Mr Caston, what if we were unable to make any finding in relation to the rights claimed by any of the individual plaintiffs? What relief would you be seeking? Mr Caston very wisely said, we'd rather like to think about that overnight, Your Honours. And we all adjourned up to the 6th floor of the High Court, where barristers go after they've finished a hearing, and stood around Melissa Caston, who's now a Professor of Law and the head of the Caston Law Centre at Monash University, but at that stage a law student and the daughter of our Senior Counsel Ron Caston. She was the only person who owned a laptop computer, and it was the first one that I'd ever seen. And we stood around her as she sat at her laptop and suggested words which she might type into the final orders which we were seeking. And as I've said a number of times before, Ron Caston was what some would call a scattergun advocate. His view was that if you have 7 judges in the High Court, you need to put enough arguments to convince 4 of them of your argument. And so we ran 13 arguments in Mabo number 1, and he wouldn't let go any of the alternatives in Mabo number 2, so we continued to claim the individual rights, and eventually we claimed the communal title of the Miriam people, which was reflected in the order the court made. But that really didn't, in my view, define what the High Court later said in Yorta Yorta was a normative society from which one draws the laws and customs which give rise to the native title. So now we are, for those of us who practice in the area of native title, we've got from the High Court saying, well, from Sir Gerard Brennan talking about an identifiable community, and using what has now been categorised as a 3-part test of dissent as self-identification and recognition as something which emerges out of the Mabo case. Well, only just, I would say, only just. And of course, in native title jurisprudence, what is now emerging is how does that kind of grouping fit in with the concept of a normative society? Is it the normative society who hold the title, or is it some subgroup of the normative society? And out of the 3-part test, there's a lot of struggle going on in current decisions about what that 3-part test means. We have dissent, and of course that now means, if one takes account of where this is going with Love and Tom's, it may mean, and this recent Montgomery case, it was a case of adoptive dissent, so not actual natural descent, but adoption. Then the second part is self-identification, which is often talked about, and then there's the third part of recognition. And the question then is recognition by whom? There's then another concept they were laid onto that, the jural public, which is a very slippery concept. What is it that constitutes the jural public? The High Court, in its various judgments in Love and Tom's, discussed some of that, and I won't go any further into that, perhaps until Stephen Keim's had an opportunity to tell us all about that. So that's really an identification, a starting point as to where Mabo fits into this current discussion. So yorta then takes us to normative society, which may have many meanings. In my experience of native title, a number of the native title holding groups have been found to hold native title sit somewhere within but below the concept of the normative society, and there might be a number of native title holding groups within a normative society. And then we're now talking, particularly following the Uluru Statement from the Heart, of First Nations peoples, which is yet another concept which is ill-defined, which may have some role in the area of normative society. But what Love and Toms, I think, tells us is that it's not about a normative, it may be about normative societies, it may be about First Nations peoples, but it is about peoples. I did attempt to obtain leave to appear in the Akiba case in the High Court. Justice French took the view that there were far too many people already appearing in that case. And although I stood up at the bar table to be given leave, after telling the then Solicitor General that the judges had read his submissions and didn't need to hear from him any further, told me that they didn't want to hear from me at all. But if they had, what I wanted to say to them was that there really needs to be a triangle. If you're talking about native title, you are talking about probably a triangular relationship. That is a relationship between peoples who may share reciprocal rights between one another, and a relationship between those peoples and land. Native title, of course, is about land, and some of the minority judges in Love and Toms dismissed any adherence to anything to any conclusion arriving out of Mabo, because they said that was solely about a relationship to land. Of course, the majority took a different view, and really what they have done is to lift out of Mabo something which is not about land, but about the relationships between individuals and their identity. Having said that, I'll leave it now to Stephen Keim to pick up and extrapolate on Love and Toms.
Great. Thank you so much, Greg, and your involvement in that Mabo No. 2 decision is so invaluable. And I guess there's so many different things we could riff off here, Stephen, but one of the aspects that came up just now is this question of how do we actually define an Aboriginal person? How do we define Aboriginal groups? And we've spoken briefly about the three-limbed test being descent, self-identification and community recognition. And each of those could be fleshed out in lots of detail. I guess what's interesting about Mabo and what's perhaps also interesting about Love and Toms is the intersection between the law and politics. Because if we take note, for instance, of the Prime Minister's acceptance speech or victory speech on election night, the Uluru Statement of the Heart was mentioned very early on in the piece, which to me speaks to the political aspects of this story as well. So I wondered, with those additional comments, Stephen, whether you had some reflections that you might like to provide to further us along this journey.
If I could just start with the connections between law and politics. 6 months ago, we had a government that was desperate to appoint 2 new judges to the High Court, and they did, so that they could bring an action or to bring some kind of application which allowed them to argue that the numbers had changed and Love and Toms was no more. Then there was an election, and the new immigration minister granted a revocation of the automatic cancellation of the visa, and then found it was unnecessary in those circumstances because there was no longer anything to argue about to continue with the appeal that had already been argued in Montgomery. So our discussion today would have been maybe very different in tone if that hadn't happened and the High Court had handed down its decision in Montgomery. It would have been, I think, a blow to the development of the law to come to terms with our colonial situation, which would have taken a very long period of time to overcome. But can I start by mentioning my son Sebastian, who married Rebecca, who was from Mexico City but had been out here studying for a while. And then they came back and lived here, and Rebecca's cousin, who's called Roxana, but we call Peke, decided that, who was like a sister to Becca, decided that she would come to Brisbane to study an advanced education degree. And Roxana teamed up with a guy called Tim Madigan, who worked at the Refugee and Immigration Legal Service in Brisbane. And Tim rang me up today in his very broad Laidley accent, I don't know if you know where Laidley is, and said, "Hey Stephen, I got this guy in immigration detention here who's an Indigenous man. Would you like to take his case to the High Court and argue that he can't be deported?" And I paused and I said, "Okay." The problem with that is that the argument is very short. You say, they've been here for 80,000 years. They can't be alien to this country, alien to this polity. And what more do you say? So, to disguise that fact, we took a much more incremental argument, which was based on the fact that each of the plaintiffs had been born overseas to an Australian citizen, and that the fact that we argued that a case of Singh, which involved a baby born to two asylum seekers from India, was not wrongly decided, but that the basis of the reasoning in the case went too far. So we argued that there was, if you went back to the law as a federation, you could either obtain membership of, or be a British subject, either through the fact that you were born in England, or you were born to either your father or your grandfather was a British subject, even though you'd been born overseas. And we said that that was a sufficient basis, and the law of the word alien in section 5119 should be construed in accordance with what was a combination of statutory law and common law, both of which bestowed rights on people and would have bestowed rights on our two plaintiffs in the case. And we thought that was a good way to disguise the radical and very short argument that related to indigeneity. So I got up to argue this incremental argument, which I thought was pretty sound, and Singh looked a bit stupid. What was said in Singh was, if you, when you were born, you owed allegiance to another country, you were automatically an alien, which is pretty stupid, because if you have a South Sudanese heritage, your family can be born in Australia for about 4 generations and you still are considered by the South Sudanese government to owe allegiance to South Sudan. So we just thought the ratio or the basis of the reasoning in Singh was stupid. Well, I got up to argue, and the context was that Clive Palmer had stolen one of our 2 days because he bought one of those applications that only Clive Palmer can bring. And suddenly, what was heaps of time was a day divided into 2 between the 2 parties. And I tried to develop my argument based on the wrongness of the reasoning in Singh. And all of these very enthusiastic High Court justices only wanted me to talk about First Nations people and my First Nations argument. I persisted for about 20 minutes trying to develop the argument in my own way, and then I thought, I'm just not going to be able to say anything. And so I went the other way. But I suppose that story is just to illustrate that the way in which you conceive of an argument is very often not the key to the argument, and how you conceive of the argument is not the way other people see the way in which the argument, see the implications of the argument and the way in which it should be developed. But having said all of that, I think between the majority and the minority in Love and Tom's is a lot to do as a sort of case study in judicial reasoning. There's a particular passage where Justice Gabler says, well, this case has got nothing to do with Mabo, because Mabo was about rights to land, and this is about section 51(19) of the Constitution. And he's right, of course, because on that level of very specific analogy, the two considerations are quite different. But both Justice Gordon and Justice Edelman used the phrase on a number of occasions, deeper truth, which seems to me to almost equate with the deeper magic on The Lion, the Witch and the Wardrobe by C.S. Lewis, which is about the Christ figure dying, but the deeper magic says actually if you do not die for other people's wrongdoing, then you come to life again. So the deeper truth is, of course, that if you look at what was said in Mabo, it actually says a whole lot of things about our law during the whole period of colonialism since 1788. And it says that many of the things that we thought about the law during that long period of time were based on nonsense. And so we have to rethink the common law, we have to rethink the way in which we approach the Constitution and try and get rid of a lot of that nonsense. And Mabo only goes part of the way. Yorkie, with its talk about normative societies, actually goes a long way to recognising eternal sovereignty for these ongoing normative societies. And this has been developed by James Cook, University Research Fellow, down to some of his articles. So the point I guess I'm really making at the end of all of this is that rethinking process has only just commenced. We have to look at all of the fake assumptions on which our law has been based and to rework them. And it's a very, very difficult process, but every colonial society that has acted immorally, as all those European societies did in establishing their colonies, have to come to terms with that history. And their law has to come to terms with that history. And we've got a long way to go yet. That's right.
That's fantastic. Thank you so much, Stephen. So there's so much that we could unpack here, but I guess if we're thinking about what's actually going on, we've got a section in the Constitution, being section 51(19). Obviously the Constitution was written in the late 1800s, and then the word alien at that point perhaps had a different meaning to how we might think of it now. But the key point for me here is that the word alien falling within the Constitution means that it's not for the government to decide who is an alien, because we're talking about the interpretation of the Constitution. And who has the ability or right to interpret the Constitution? It's not the government, it's the High Court of Australia. So yes, the High Court the government can decide who is a citizen, but they can't decide who is an alien. And of course there's going to be a crossover or a nexus between those concepts, but they're not the same thing. And so we get into some curly language here where we might talk about a non-alien citizen, or and there's all sorts of other variations. So, the Honourable Michael Kirby, I'm interested, I guess, in your reflections here about that latter point of the role of the High Court in interpreting the Constitution, and in a sense the way in which that intersects with really important doctrines that sit underneath liberal economic democracy, like the separation of power and so forth. Interested in your reflections, whether those reflections relate to Mabo number 2 and Love and Toms, or in a more general sense.
Well, first of all, let me pay respects to Stephen Keim. I told this conference a little earlier in the afternoon at a launch of the MKC chambers after me of the work we had done, Stephen, I and others, in Brisbane last week on the celebration of the passage in Queensland of the first law to abolish capital punishment in Queensland and at that time the British Empire. And that was an indication through the legislative process of a willingness in Australia to do something really original about the law and to think freshly about the law. Many people in 1923, or 22, 23, would have thought it's ridiculous to talk about a criminal law without a provision for capital punishment, because capital punishment had been part and parcel and a very important feature in the criminal law of the whole British Empire. And yet there they were in Queensland, the electors having returned them to Parliament, getting rid of capital punishment. So that was a very interesting conference. And I think it's great, isn't it, that Stephen, who is a top barrister, he's used to girding his loins, putting on his wig, putting on his robes, getting dressed, going down to court, bowing and scraping and putting the arguments to the judges, and yet he's actually a very important educator. And it's a pity that more barristers don't do this, because they are very clever people, but most of them, they don't feel confident enough to do it, and they're not all that interested to do it. It's enough for them to argue in court, but Stephen takes big issues out of the court, and using his tremendous skills as an advocate and as a barrister, thinking through particular cases to teach big lessons. So Stephen, I want to say to you, for over here on the opposite side of the continent, you're terrific. We need more lawyers like you. Don't go looking there very modestly and looking down at every now and again, a judge or even an ex-judge has got some nice things to say about barristers, and in particular Stephen Keim. So let us all, as Australians, thinking on Stephen's contribution to a very big conference on the death penalty, which isn't now such a big issue in Australia, but it sure is a big issue in our region and around the world, and we haven't forgotten the people of the rest of the world, and we're trying to speak up for those in Singapore, in Malaysia, in Afghanistan, and in so many other countries, China in particular, which has the biggest level of capital punishment in the whole world. We're trying to say the lessons we learned, that you can get by without the death penalty and you can learn from the lessons of other people. I think we should all give a big round of applause to Stephen Keim KC. I didn't sit, self-evidently, because I left the High Court in 2009, so I wasn't a party to the decision in Love, and I therefore did not take part in what I would call was the constitutional thinking that lay behind the decision in Love. And I've got to be a little careful commenting on what was done by colleagues in cases argued since my time. I remember so well going downstairs from our chambers on level 9 in the beautiful High Court building. Well, the Duke of Edinburgh said he thought it looked like a power station, but actually inside it's a very comfortable, very well attended, very well libraried and lovely place. And my chambers were the loveliest of all, being made with very nice wood from Tasmania, golden wood. I lived my life in the High Court in a golden pond. I was there, well, the pond was Lake Burley Griffin, but it was a lovely place to work and very nice. And when we would go down in the morning and there was something in the newspaper about a former justice having said something, Justice Hayne would come down and slap his forehead and say, "Have you seen the latest thing that the mothball fleet have said?" And I don't want them to go downstairs to level 1 or level 3 for number 1 court or level 3 for number 2 court and slap their heads and say, "Did you see what Kirby said in Perth?" Because they have the responsibility and they have to decide the matter with their responsibility and their authority. So I'm not going to comment on that. But I'd like Stephen to reflect upon the fact that Justice Gagler, who's really a very broad-thinking Justice of the Court, he was Solicitor General of the Commonwealth. He's not a narrow property lawyer who's been transferred into the High Court of Australia. He's a big thinker. And yet it's fairly clear that he was very upset by your decision, by the decision you persuaded the High Court to take. He was very upset with his colleagues, and that makes me pause and ask, why was he upset? And I think the answer to that was because they were challenging some deep fundamental thinking that had gone on for so long before. But I'd be interested to hear Stephen's comment on that. But earlier today, this morning, when I talked about the marriage power and the earlier decision about whether or not the marriage power in the Australian Constitution permitted the Parliament or anyone else to narrow marriage as marriage only for heterosexual people. I mean, to me, admittedly someone affected by this argument, to me it would not be a particularly surprising constitutional thinking to say this is not just a tin pot statute in London or anywhere else in the world talking about marriage. This is our constitution, and in our constitution our power to make laws for marriage not only cannot restrict it to heterosexual marriage, man and a woman, to the exclusion of all others for life, but has within it an assumption that it's there for everybody. And if that had been so, then somebody could have gone up to the High Court and said it is implicit in the Australian Constitution that we already have a capacity for same-sex marriage because the power must be neutral about sexuality and must be available for others. So this is sort of constitutional thinking. And so when I heard about the decision in Love, I wasn't particularly concerned about it. And I certainly wasn't concerned enough to really get hot and bothered and to say this is really a horrible suggestion that is undermining everything that has gone before, that Parliament cannot cut down what is there in the Constitution. And if alien and Aboriginal status are both in the Constitution, then reconciling them in a way that ensures that you cannot deprive an Australian Aboriginal as defined, which may itself be a matter of question, but you cannot deny them that status as against the alien status. And that's essentially all that Love did. And I didn't find it shocking. I didn't have a heart attack when I saw it. I didn't go into the bathroom and sob and cry at this fundamental mistake in our constitutional thinking. But Justice Gageler did. I mean, he didn't go to the bathroom. he was upset by it. And I've seen and I've heard that this is something he thought was just fundamentally wrong. So, Stephen, could you explain to us why, for Justice Gageler, a very forward-looking and broad-thinking constitutional lawyer, was so upset by what you persuaded the majority of the High Court to decide, and what are the lessons in Justice Gageler's anxiety and upset about the Love decision that led to the Montgomery case, and except for the political intervention by the new Attorney General, could have seen that all unravel. So can you explain that to us? I haven't studied the reasons for Justice Gageler as closely as you will have done, and maybe you can explain why do we get so hot and bothered about these things, and why do some people think that you can't rethink issues by reference to constitutional thinking? Justice Toohey did that, you know, in a case concerning the provisions for implying into Chapter 3 an implication that you will conduct it with due process of law. The issue rose in a number of cases, but one issue it arose in was the suggestion that Parliament can cut down on due process of law by enacting that particular provisions will declare that the law is such, have a presumption of that. And Justice Toohey said, no, you can't do that, because our Constitution in Chapter 3 implies that everybody will be dealt with fairly, with due process of law. And it's just inherent in the type of legal system we've got in Chapter 3 that that is implied, and that is a limitation on what Parliament can do. And that was constitutional thinking. But in Australia, because of the British tradition, we've not been used to constitutional thinking. And I understand what Stephen Keim has said today is we've got to shake that off. We've got to be willing to think constitutionally, and that may take us into new territory, and drawing lines may sometimes be difficult, such as who is an Aboriginal. It can't be self-defining entirely. It has to have some objectivity. But why is Justice Gageler so upset about the decision in Love? I'm not surprised that other justices will be upset. I'm not surprised that the justices didn't agree with Justice Toohey. But I never had a problem myself in thinking freshly about the Constitution. But some people do, and I'm just surprised that Justice Gageler does, or did in this case. And could you explain from his reasons what his thinking is that finds the Love type of reasoning so offensive to his understanding of our Constitution? I think we have to know that, because he's a very clever man, he's a very experienced judge, he's a very experienced federal lawyer as former Solicitor General, and he's not a narrow person. He's a big thinker. So that's my question for you.
So Stephen,
Relevant to love.
the Honourable Kirby has thrown down the gauntlet. So, but before I get you to answer that question, I guess just for the benefit of those who are not so familiar with the Love and Tom's decision generally within the room, to make the point that this is a High Court case with 7 different judgments and a 4-3 majority. So obviously. It wasn't a unanimous decision, and there was contention here in relation to these critical questions. And earlier, Stephen referred to this notion of a deeper truth and alluded to Justice Gordon and Justice Edelman's judgments. So in that light, Stephen, are you willing and able to answer the question that's been put to you?
Yeah, I really appreciate the Honourable Michael Kirby giving me all the easy questions. Can I start by saying that my friend Patrick Keane, who in his private life loves cricket, and contrary to Anglo-Irish people, seems to have a very, very strong support for Republican Ireland, which is probably
That's
a way of feeling. That's probably a way of feeling that I identify with a little bit more than Michael does. But Justice Keane's got this great ability to sit back in court and to think of the most difficult question that he wants to challenge the person who he doesn't agree with, and come out of it with this great gotcha. Yeah, but what about this thing? And I'd have to say that the judgments of Justice Keane and the Chief Justice, Susan Kiefel, actually read like one of those gotcha questions that Justice Keane comes up with. But the tone of Justice Gageler's dissent is actually more in sorrow than in anger. He actually sort of talks as if he empathises with what our argument was, and at the end sort of says, but it cannot be. I think the real answer to the question is, and I've certainly heard that the minority in the court, a number of them were very upset, and it caused some division within the court. But it seems to me that it goes back to what I mentioned when I spoke earlier, that, and it really is a process of differences in judicial approach to a particular problem. And it often is, at what level of generality do we look at the precedents, and at what level of generality attack this novel question in the law. And the majority were informed by Mabo and the rethinking of the false assumptions on which our law had developed, and were able to think about it at a higher level. And the minority, including Justice Gageler, felt that this was just a very specific comparison with something which was about X, and these people were trying to make it about Y. I think that's where he found not only our argument, but the conclusions of the 4 justices who disagreed with him to be in some way offensive to him. But I think also that there's a little bit of history of the approach to Section 5119, which I adverted to before, which is that, and Pottier McPhee, I suppose, is where it's best expressed. And in Pottier McPhee, they sort of say, it's almost open slather for the Parliament to say what an alien is. And obviously that can't be true. What Section 5119 means when it uses the term aliens and naturalisation, it has to be a constitutional question. Structure of the word in the context of all of the things that you use to construe a constitution. And in many ways, the decision of the majority in Love and Tom's is a black letter law response. It says, there's a word here, it's alien. What does alien mean? It means strange, it means unassociated with us, it means different. And the answer they came up with was, well, you can't be an alien if you've lived and formed a crucial part of this polity for 80,000 years. That's a black letter law response. And in many ways, to suggest that the majority got it wrong because they used all of this woke nonsense about First Nations people, that's fallacious arguing in my view, because in many ways the construction of the word alien is a black letter law question, and it was answered in black letter terms, particularly by Justice Gordon and Justice Elmer. And the misunderstanding that Bocci and McPhee has, which is there was a smorgasbord set of views around the world as to what an alien was. There was jus soli, where you were born, and jus sanguinis, who you were related to, and the Parliament can take any dish it likes off that and say that that's what makes an alien. It's just clearly wrong. The thing is that both jus sanguinis and jus soli were a source of human rights to be part of the polity that constituted Britain in 1901. The meaning of alien at any time subsequent then, if it's not at least as generous as the law in 1901, that has to be justified in terms of constitutional interpretation. So I think in many ways, this approach by giving too much leeway to the government, to the Parliament, in terms of what an alien is, and not giving enough rights to people who are connected with Australia in a number of different ways, and it's acknowledged that a recognition of the rights of Indigenous people having been here for 80,000 years is a further basis for being connected with Australia, but is in addition to jus soli and jus sanguinis. But this view that the Parliament could toss anybody out and call them an alien and treat them very badly and deport them from the country is a fallacious view of the Constitution, when in fact, as Michael Kirby has just said, it's a constitutional question. It has to be construed in constitutional terms. Thanks, Robert.
Thanks so much, Stephen. So I'm going to invite some questions now from the student body, and best for me in the first instance to turn to a representative of the Curtin Student Law Society. As I often say, the Curtin Student Law Society is the soul of this law school, and Megan Levy has the role of Careers Director and has been instrumental in organising today, so thank you, Megan, for your work. And I'm going to invite you to ask the first student question, and there may be others, and what I'm going to invite the panel to do is just to see if we can do some snappy answers. I might just choose one person to answer the question, and then we'll try and move through 3 or 4 questions in the space of 10 or 15 minutes, if that's possible. So we'll see how we go, but how we go.
I just wanted to know that when obviously the Mabo decision was heard in 92, since then obviously it's evolved to different cases such as Love and Tom and Helmbright. Just wanted to know that in 92, when hearing the decision and writing the decision, did you ever consider that it could be interpreted in such a way? And obviously with it being more talked about now, in the future, what do you see for its interpretation and how the 3-part test is going to come into play?
Thank you so much, Megan. I might invite you, Greg, if you're happy to have a go at answering that question. Difficult one, but
I don't think we've thought too much about what the Mabo decision would evolve into. Yes, certainly, in my view, it's the correct evolution, and in fact it needs to. There's another evolution, which is the recognition of intellectual property rights, which the High Court in Ward decided they wouldn't go that far, but I think it is open to that, and it does mark a watershed where the High Court really did come back to some basic principles, and that's probably why it's created this small avenue for Love and Toms and has some other potential.
Did you want to?
I'll usually pass it around.
Yeah. Yeah, any other questions that you've got from the floor? So while you're thinking of your questions, and just put up your hand as it comes, I'll just consolidate. Actually, I'll just take it and then when someone puts up their hand. Just to consolidate, where we have gone here. As I indicated earlier, and as has been reinforced, we've got a situation where we've got text in a constitution, and the role of the interpretation of that text has to fall with the High Court, and in some ways that reflects some very important principles about how our liberal economic democratic system works, because it creates some boundaries and constraints which I guess each of the 7 judges in the High Court sought to grapple with within their judicial reasoning. And as Stephen mentioned before, in a way, Love and Toms is a case study of judicial reasoning. So I'm hoping that if you haven't had the opportunity to look at the case, that after this session you are inspired to go off and read it, because if I had to direct you to just one High Court case, I would probably direct you to Love and Toms at the moment, because I think it's very interesting in terms of where it might be going. But any questions that you might have from the floor? Thank you, Samantha. Perhaps you say your name before you. Thanks, Stephanie.
Hello, my name is Stephanie. This is a question for you, Michael Kirby. Thank you for being here today, by the way. I read on your website that Owen's case, the Aboriginal young man and his friends at the cinema, was one of the most important cases of your career. I was just wondering, considering that was in 1965, how do you think that would be looked at now, given the Love and Toms and also the Mabo decision in today's view of the Constitution?
Well, first of all, the Love and Thomas case was being challenged by what I'll call the former approach, and that was terminated by the new Federal Attorney General, which was within his power, and that was done. But that doesn't stop the Justices of the High Court in other cases reverting to the issue which was terminated in the Montgomery case, and therefore I think it's a matter of watch this space. I think we'll continue to see challenges to this. But I just hope we will all do what essentially Stephen Keim urged us to do, and that was to be ready to open our minds to a broader interpretation of our Constitution and words in the Constitution and what they mean. Mabo was not a constitutional case in the sense of a case concerning the interpretation of a provision in the Australian Constitution, though it was probably affected by the constitutional developments that had recently taken place, such as the referendum, the removal of the provision excluding federal legislation on Aboriginals, the door that opened, and so on. In fact, I was chairman of the Law Reform Commission from 1975, and with the dismissal of the Whitman government at the end of 1975, we got a new Attorney General from the coalition, Bob Ellicott. Now, Bob Ellicott was a person who was very concerned about Aboriginals, and he gave the Law Reform Commission a reference on Aboriginal customary law and what we should do about it, how should it be recognised in any way, using the power that had become available by reason of the referendum in 1967. And no government since 1975 has acted on the report of the ALRC in that respect. This is surprising on one level because the report was written by Judge James Crawford, a very distinguished Australian who became a judge of the World Court. And the evidence of the hits on the ALRC website show that the report on Aboriginal customary law is the report of the ALRC that gets the most hits of all the other reports, including others, including some that were written by James Crawford on Admiralty law. They don't get anything like the interest that the report on Aboriginal customary law gets. So, in one way, I have a theory that the interest in Aboriginal customary law, the work of Judge Crawford, became a stimulus to altering the zeitgeist, the spirit of the times that had existed before, and in a way may help to explain the fact that we were beginning to talk about these things. Take it from me, prior to 1967 and the referendum, there was very little talk about law and Aboriginals. Essentially, Australians thought they're all going to die out, we're not really very concerned about them, they're a tiny minority, and we don't have to worry about them because they're not going to be around for very long. Well, that hasn't proved to be right. And what has proved to be right is that gradually, there has sunk into the psyche of the Australian population that zeitgeist has changed. And we are now beginning to see that even by the law of international law in 1788 or in 1770 when Captain Cook came here and on Possession Island in northern Queensland had presumed, contrary to his royal instructions, to lay claim to the whole of the eastern coast of Australia in the name of King George III, we suddenly began to question these ideas. And back in 1770 and 1788, a country like Great Britain could only lay claim to lawful acquisition of another territory either by conquest, which Captain Cook and Captain Phillip didn't do, or by cession, like in New Zealand, in a treaty between semi-equal countries, which we've never done in Australia, but it's now being considered makarata for our dealing with Aboriginal, or if it's an empty territory. And that was the hook on which we hung, the idea that Captain Cook on Possession Island could lay claim because it's an empty territory. And now we know it wasn't an empty territory. And now we're beginning to look at the massacres that took place, that there was resistance. And this is something in my youth you never talked about, and you never heard anybody talk about, and you never asked any questions at law school about it. But we're now thinking freshly about it. So in that sense, and this is my point, Mabo was not a constitutional case in the interpretation of the constitutional text, but it presented a new zeitgeist of the context of the word Aboriginal. And that is a constitutional word. And that is something upon which the decision of the majority in Mabo casts light. And therefore it isn't true to say that was just a land case. To say that is not to pay regard with respect to the flow of history, the changing views and the greater openness of Australians of your generation and of Stephen's generation and even a few of us of my generation to re-question all those assumptions on which we based the sovereignty of Australia. And so with the gotcha questions, it doesn't get you. It only gets you if you don't have regard to the fact that the Constitution uses the word Aboriginal, and that things that have happened in Mabo both illustrate why we're changing the process nationally of changing our mind, and why the High Court in the Love and Thomas case, really it was a black letter exercise. The Constitution uses that word, it uses the word alien, and you have to reconcile the two words. I don't find that a particularly surprising reawakening or awakening. And I think history will judge the decision in Love and in Thomas to have been on the right track. The question is, how do you define Aboriginal? I mean, this was one of the points that the minority in Love latched. You can't leave it to Mr. Love to define himself into the Constitution. You've got to have a pre-event understanding of the word, and you can't just let a New Zealander who is a New Zealand national, has a New Zealand passport and so on, say, well, yes, but for the purpose of your Constitution, I'm an Aboriginal, and that's because I claim to be an Aboriginal. There is a factual question there that has to be determined by evidence. But all they said in Love and Thomas was, if a person is a First Nations person, then they are not competent to be an alien, because the two concepts are constitutional. They have to be reconciled.
Thank you so much. So one of the things we haven't really fleshed out, I guess, is where the three-limb test came from, and there's many ways of answering that question. But one place to point to is actually the Tasmanian Dams case, which is not known as much at this point. It's known for other reasons in the environmental law domain, but that is one area where, or Justice Dean in Tasmanian Dams case pointed to that tripartite test of descent, self-identification and community recognition. Each of those can of course be fleshed out. And I think Greg has one more comment to make, and then I'm going to call for one more question from the floor, and then we'll wrap it up.
One of the big issues which Michael Kirby just touched on is who is it who makes the decision, or who assists the court effectively to make the decision as to who is an Aboriginal. And if you look at the third limb, so-called third limb of the test, you have this concept which I mentioned before of a juror public. Justice Mortimer in the Federal Court had to deal with that 2 years ago in the Penalulu National Park case, where there were two competing groups for native title. And the question was whether they were, who was to decide. I was acting for a minority group. There was a much larger group represented by the Kimberley Land Council. The much larger group said, we don't recognise those people whom I was acting for as native title holders. We don't recognise them as connected to this country. And effectively, I mean, it wasn't quite whether they're Aboriginal or not, but whether they were a particular group of Aboriginal people. And so the issue became, well, who decides, and if so, when do they decide? And the other parties were saying, well, we have decided. We're not letting these people into the group. And I was successful in the argument with Justice Mortimer, who said, well, no, it's not a case of a case for contemporary decision based on what might be then current animosities. One has to look at the history of the taking into account the traditional laws and customs. Who is it that the group who are the juror public who make that decision, and is there an historical integrity to that decision? So that's a broader question which did come up in the Tom's case when the court had to consider that issue. That it's not just a case of, oh, well, you go off and you find some Aboriginal person who will say, oh yes, this person is Aboriginal. But it does actually have to have an authenticity based in tradition.
Thank
I
you,
just
Greg.
add one very short sentence. Lionel Murphy used to tell me, I always go to bed with a copy of the Australian Constitution beside me. And in the sleepless nights, I turn on the light, I open the Constitution, and it's amazing what I see there and what I can find there and what may be false or may be true. But we've got to get fresh eyes to look at it, and that's quite difficult given our legal history. But I think we all, and certainly all of you, should remember what Lionel Murphy said. He was a very clever man, and a lot of the things he said have been adopted by later reasoning, not always with acknowledgement. But put the Constitution beside your bed tonight, keep the light on, sit there, look at it, and you'll be astonished at what you see and what words may mean and what arguments may flow from the meaning of the words in the Constitution. If you think Constitution, not narrowly or just in statutory or common law terms, but Constitution. This is our invitation. Our Constitution's a very old document. It hasn't been formally changed very often. It's very difficult to change it. And studying those words is a very important thing for law students and lawyers, because you may be surprised at what you find.
Wonderful advice, and of course the way in which our Constitution is structured as well means that just by virtue of the chapters, for example, those critical fundaments of our system, like the separation of power doctrine and so forth, make their way into the very structure. I think, Tanya, you had one more final question, and then we will try and wrap it up. Thank you, Tanya.
Hello, I'm Tanya D'Souza-Millie. I have a question about how you think the High Court in the future might consider legislation that either follows or does not follow the advice from the future First Nations voice to Parliament in the consideration of constitutional questions, particularly around identity and so forth, considering that the voice will be enshrined in the Constitution.
Well, what do I think about it? I think that the appointment of 2 new justices of the High Court, which is coming up very soon, the replacement of Justice Keim in October of this year, and the replacement of Justice Keefer, the 2 Queensland justices, is going to form an opportunity. I floated the idea with everybody who would listen that Stephen Keim should be appointed. But very modestly, I mean, he says he's actually very ancient. He looks young and he's full of energy and imagination. But your question's a good question, because one of the points we're going to hear a lot about, if you read the Uluru Statement, is a makarata, is a treaty. I mean, why did we not have a treaty with the Aboriginal people? Answer, because we were an empty continent and they were not resistant and there was no need for a treaty. Therefore, we didn't do what the New Zealand Maoris did. But history, actual anthropology and history, tend to suggest that was not a correct statement. And we may see, coming out of the voice, down the track, the development of a constitutional makarata to get back to the 1850s, where the Maori, in the Treaty of Waitangi, negotiated a much better deal for themselves and for their children and for their economics and for their power in the land than the Aboriginal people of Australia have ever been able to negotiate. It's an issue on the agenda, and it's there in the history of the Uluru Statement from the Heart. This is a claim. The first claim was for the voice, and the second claim was for the makarata. And you will see, I may not live to see it, but you will see this played out in the history of Australia. And when that happens, they will point to Love, Thomas, and they will say, "Who was that very clever barrister who argued?" And they will say, "That was Stephen Keim," and he upset quite a lot of people.
So for the benefit of Stephen, I'm going to direct the attention away from you, Stephen, and towards the Honourable Michael Kirby, because as is always the case when we sit down to have a conversation with you, Michael, we could sit here for many hours and continue this discussion, but unfortunately the clock has beaten us. But can I do what the Honourable Michael Kirby did prior in relation to Stephen, which is to divert our attention to the Honourable Michael Kirby and to thank him for coming here, for being involved in this session, but also for all of the past services that he's provided to the legal profession and to the judiciary more generally. So thank you so much. And just again to consolidate, I guess, a few points along the way. There's so many more discussions that we could have had in relation to this general theme. One of the things that I know Stephen would have had much more to say is the question of community recognition, which was something that Greg was alluding to earlier, in the sense that how do we define who the community actually is, who recognises an Aboriginal person. And one of the issues that arose in the Helmbright matter that we were also involved with was the question of the extent to which a Mabo perspective or a native title perspective of community recognition might be relevant to defining what the relevant community is that makes the determination as to who is an Aboriginal person. And so that is a whole can of worms that perhaps is a discussion for another day. But there are some themes that have come out of the discussion today, such as a deeper truth, zeitgeist, the notion of a treaty, all of which speak to the intersection between politics and the law. And obviously constitutionalism is where we see that intersection most pointedly. And I hope that this discussion today has inspired you to think more deeply and to engage with these issues that remind us that the law is not handed down from heaven, but is made by human institutions, but met through human processes, and that hopefully we can all join together to influence what that law might be, both now but also in the future. One of the things that I took away from the speech this morning from the Honourable Michael Kirby was this idea of the joiner, people joining together, joining the dots, if you like, to understand, as I say, the intersection between law and policy. And another person that was sitting on the table this morning was Fred Chaney AO, and when I was having a conversation with him some years ago about ideas that I had about the law, he said, "You know, I think that what you might be is a little nudger. You're just trying to nudge the law one way or another." And I always, that idea of being a little nudger was something that spoke to me, and actually thought about it when you were talking about being a joiner this morning. So once again, thank you for coming along today and for being involved in this what is in a sense a historical session. And yeah, thank you again to you, Michael. Now I'm going to hang around. If you've got any questions that you'd like to ask about anything that we've talked about, feel free to come up and have a chat. But I think we need to give the Honourable Michael Kirby a bit of a rest, because we've got dinner tonight, and we've been wheeling him around the place all day. So you can take leave, Your Honour, as you can too, Greg, and we'll reconvene at dinner time.